Hello. We're going to talk about student searches. And no matter what grade level you work at, sooner or later, you're going to have to search students. I've been a principal of an elementary, middle, and high school, and uh, I've had to search. I've had elementary kids, kindergartners, who stole their mom's wedding ring and brought to school. I had another elementary kid stole the car keys and brought it to school. I've had them steal money out of teachers' desks. Even if you have special ed students, I've had a life skills student who stole a couple $1,000s from their daddy's dresser and came to school and was handing out $100 bills to people. So at some point you have to search. And the key is you need to balance those students' rights with the school's need for safe learning. And their rights, as we've talked about previously in this course, are protected by the Constitution. And it's the Fourth Amendment, which protects against illegal search and seizures, that really protects them when it comes to student searches. Now, if you do it well and do it right, searching a student is not hard, and you'll never get in trouble. If you don't do it right, it can come back and bite you in the butt. And the thing about it is, if it's an illegal search, then whatever evidence you find or whatever punishment you gave will be thrown out. So it behooves you to make sure you search correctly. Now, the other thing I want you to understand is this. Every child's innocent until proven guilty. And I always would tell them that when I search them. That I'm having to do my job. It's part of my job to keep school safe. But that I really don't want to find what I'm looking for. I'd rather have the child be innocent. If the child is guilty and I find it, then of course the rules apply. If the child is innocent, then the child's innocent. So we'll talk a little bit about that when we get to it, okay? So the Fourth Amendment, until 1985, and I'm, by the way, going to get rid of sorry about that. Let me get back to it. Prior to 1985, doubt existed whether the Fourth Amendment actually applied to students at school. Prior to that, parents, you were in loco parentis. You were in place of parents. And parents, of course, are allowed to search children. Well, in loco parentis is no longer a legal thing. I often use it in talking to parents and students because it was in Latin. It sounds like you know what you're talking about. And I tell a kid, I have in loco parentis in place of your parent. It's legal. And the kids are like, ooh, you know a lot. But in 1985, there's a huge case, one of the most important cases you need to remember as a school administrator, and that is New Jersey vs. TLO. TLO was a 14-year-old female student. Her and another girl were in the bathroom smoking in the girls' room. And they got caught and were brought to an administrator who questioned them. And the thing about it is, the second girl said, oh yeah, I was smoking. And the first girl, TLO, said, no, I wasn't. So they accused her of lying and then demanded to see her purse to find the cigarettes. While looking for cigarettes, they found rolling papers. Now, rolling papers, I've never smoked it, but according to what I've been told, if you have rolling papers, then you've probably been smoking marijuana. So therefore, since you found the rolling papers, she searched further and found actually some marijuana, drug paraphernalia, a pipe, some money, and even some names of people that owed money to her, and a letter saying that she was dealing. So they contacted the police, they contacted her mother, and she confessed to selling marijuana. It went to juvenile because she was 14, and the juvenile took to court and said, we need to suppress the confession because searching the purse was in violation of the Fourth Amendment, which was a novel at the time because it had not been used really before. And anyway, the court found that it was not a violation of the Fourth Amendment and that she was delinquent. She was put on probation for a year. And then it started getting appealed, and it appealed up through the New Jersey system to the Supreme Court. And I want to show you that. Now, I'm going to show you the whole way this thing was appealed. Because when we talk about Supreme Court cases, we just believe that it went from one case, boom, to the Supreme Court. And this gives you an idea. This is kind of interesting, and I'm going to just hit the highlights. You need to go back and read it. But this gives you an idea of the process that goes from the first case to the Supreme Court and the variations in what people think. Okay, so this actually goes to juvenile court in New Jersey. And the first court said that a Fourth Amendment does apply to searches by school officials. Remember, they weren't sure if that was true or not, and this juvenile court says it does. And that if they have reasonable suspicion. Reasonable cause is necessary because you're responsible for keeping the school safe. And so they said because of that, because of smoking, because the Warren girl admitted it, that did not violate the Fourth Amendment. That the principal had reasonable suspicion, reasonable cause, that TLO had it. And so they find her delinquent and give her probation. Well, the TLO's lawyer appeals it, and it goes to the appellate division in New Jersey. And there, they affirm the juvenile's decision, saying it's not a violation of the Fourth Amendment. But they said you need to take away the delinquency, she's not delinquent, and you need to send it back to the juvenile court. And it's interesting here because they said, did she waive her Fifth Amendment right against self-incrimination, which was not even brought up in the earlier court or even by the principal or by the judge, or by the lawyer. So the judge is saying this is not in violation of the Fourth Amendment. However, did she waive her Fifth Amendment right to self-incrimination when she admitted after she went down to the police station with her parents that she dealt marijuana? Okay. So then, it went up to the next court, which is New Jersey Supreme Court. There, they agreed, well, the Supreme Court essentially overturned and said that the school administrator's conduct was not reasonable because possession of cigarettes did not violate school rules. And so the principal had searched the purse not because of cigarettes, but because TLO lied. The other girl said, yes, they were smoking. TLO said, no, I wasn't smoking. So he's searching the purse not for cigarettes. He's searching the purse to catch her in a lie. And they said that is not reasonable suspicion. And did not justify rummaging through a purse. So the higher court, the New Jersey court, really says, Court 1, Court 2, you're wrong. This is what it's going to be with. They do, however, agree that the Fourth Amendment does apply to school officials. So all three courts have said that the Fourth Amendment applies to school officials. That then gets appealed by New Jersey. The other three had all been appealed by TLO's lawyer. Now, since they lost, New Jersey, the state says, no, we're going to appeal it, and it goes to the Supreme Court. Here's what I want you to look right here. This is really what the question is. And the question is not whether the search was unreasonable. It's not whether even violated the Fourth Amendment. Look what they're asking. Whether the evidence unlawfully seized should be allowed as evidence in the juvenile delinquency proceedings. So this is kind of a very direct and very narrow look at what the Supreme Court's looking at. So they're really not addressing whether the Fourth Amendment applies to school officials. They're not addressing whether the principle was reasonable. They're saying, if it's unlawfully seized, can that be used in juvenile delinquency proceedings? All right? And the Supreme Court did not react to that issue. In fact, they even kind of turned and went back to the Fourth Amendment. And they said the search of the purse did not violate the Fourth Amendment. All right? Now, they never did get to the part about if it's unlawfully seized, can it be used in a hearing? They never got around to that. You can see where it was argued. It takes a while, by the way, for courts cases to go through the Supreme Court. This is almost half a year, a little more than half a year from when it was argued in front of the Supreme Court, re-argued, and then it was decided by the Supreme Court. And so there's just some information about who wrote the majority opinion. And normally what they do is they'll write a majority opinion that's 5-4. So whoever's in the 5, they pick one person who writes a majority opinion of what all of them say. Then there are those who agree with the majority. They can say, I want to write concurrence, which is a little more. And then you can either write a concurrence in part and dissent in part, or you can write a dissent. So if you voted against that as a Supreme Court judge, you could actually write a dissent, a dissenting opinion. So this just shows you who concurred, who dissented. But here's the key things about this. And this is why this is an important case. The Fourth Amendment prohibition of unreasonable searches and seizures is not limited just to police. It does apply to public school officials. You're an agent of the state. No, you're not agents of the parents. In loco parentis does not exist. You're in loco state, in place of the state. You are the state. And so therefore you must follow the Fourth Amendment. And they said that students do have some legitimate expectation of privacy. But that privacy at school must be balanced against the need for safe school. Right? Because of that, they said what makes that search legal or illegal then is the reasonableness of the search. Okay? It's hard to say whether one search is right or wrong. You have to look at how reasonable the search is to determine whether that search was right or wrong. And so they came up with a test, and this is an important test. You need to remember this. This is key. There's 2 tests, TLO test. One is, was the search justified as inception? Okay? And that's where reasonable suspicion comes in. We'll talk about that. The second one was, as the search was conducted, was it reasonably related in scope? So that means the search was it related to the scope of the crime or of the alleged crime? So if we go back to TLO, the principal searched a purse. Right? That's pretty reasonable related in scope to looking for cigarettes because you think the child smoked. Right? It would not be reasonable if that principal told TLO to strip down to her underwear to see if she has the cigarette stuck in her bra or underwear. So, those 2 tests are vitally important because if you miss one or either of them, your search may be thrown out. Okay, you gotta have both of those. It has to be justified and it has to be reasonably related in scope. And so if you look down here, they evaluated the facts in the search of this test. They said, let's look at this test and let's apply TLO to the test that we just came up with. Right? And they said that smoking in violation of school rules constituted a reasonable suspicion. One girl admitted they smoked. TLO denied it. The fact that one girl admitted it and there was smoke in the bathroom gives that principal reasonable suspicion to believe that TLO smoked. The second one then is that the discovery of rolling papers also provided reasonable suspicion that TLO possessed marijuana. And that then justified the further search. Okay? And it was reasonably related in scope because they're just looking at a purse. And so the Supreme Court said they did not violate the Fourth Amendment. Now, in concurrence, those people agreed with them, but a couple went even further, though, and said that the school may not afford students all the constitutional protection they would otherwise have in a non-school setting. Some wanted to go even further and say kids really don't have any constitutional rights in a non-school setting, they would otherwise have in a non-school setting. And then Justice Blackmun here, you can see where the need for school authorities to immediately respond to threats and safety should justify special exemptions for the Fourth Amendment warrant probable cause. So again, Justice Blackmun is the one who said they need to go further, that if this is threats or safety, then the Fourth Amendment doesn't apply at all. And it would have made it a lot easier for school officials to search. But again, that is a dissent. So let's move on down here. And you can read this yourself. And please do go back and read this. I'll post this I guess over time you can read it, but I'll post these notes also in addition to this video so you can print out and have copies of them. All right? So, here's the importance of it. It sets a standard for student searches, and that is reasonable suspicion. And reasonable suspicion is justified or satisfied with two conditions. Was the search justified? That means, were there reasonable grounds for suspecting the search will reveal evidence? Was there reasonable suspicion that that person has it on? Okay? That they violated or are violating laws or school rules. The second is, it has to be related in scope. Okay? The measures used to conduct the search are reasonably related to the objectives of the search, and not excessive in light of the student's age, sex, nature of the offense. Now, the interesting thing is, since then, schools wanted courts to really kind of define what is reasonable suspicion, because that is a very general term. What is reasonable suspicion? And so there's a number of cases, and those are them right there. And you can go look at these. So, for example, the first one, 4 students huddled together. One had money in their hand, the other one had it in their pocket. That's not reasonable suspicion. You know, there's multiple reasons why someone might have their hands in their pocket. An anonymous phone call. That does work, especially since you look at the student's reputation. So I used anonymous phone calls when I wanted to search somebody. I'd always have, you know, your history is not supposed to dictate your future. However, if you have a habit of hanging out with drug dealers, or there's been talk about you smoking weed, and then I get an anonymous call saying you may have it on you, I'm going to search you. If I have an A honor student that, you know, is virginal and has never done anything wrong and has never broken a school rule, anonymous phone call, it's going to be a little harder to create reasonable suspicion because of that. A good example of that is, I had a friend whose son was in high school. His son probably could identify any drug if he had to. He was really naive. He read nonstop. Probably the biggest nerd you've ever seen in his life. And an anonymous phone call was made to the high school saying that he had drugs in his locker. And so they went and searched his locker, and sure enough, there was a bag of pot in there. So they essentially said, we're going to suspend you from school for the rest of the school year. Turns out that someone was mad at him and had planted, those lockers had vents in them, and someone had pushed the drugs up into the vent, into the locker, and then had called to get the kid in trouble. But that probably should have never been a reasonable suspicious and reasonable search, because that kid had never done anything wrong. Right? Keep going on. You have another one with a gun at the school. That constitutes reasonable suspicion. And then someone who has bloodshot eyes, dilated pupils, that does it too. There's a few more talking about if you've searched everyone in class, but the one person's not been searched yet, and the item's not been found, that gives you reasonable suspicion, and so on and so forth. Okay? Now, probably the best description of reasonable suspicion is really just the consideration of everyday life. So, what is reasonable to a normal person? Right? If a normal person thinks that there's a reasonable chance that that person has it on him, then go ahead and search him. Okay. Now, these cases are old. This Littleton, Jonesboro, Springfield, West Paducah, and Pearl, those were school tragedies. Those were minor compared to what's happened recently with Stoneman Douglas and others. But school tragedies have really pushed the pendulum on searches way to the favor of the principal. So the right of school officials to conduct searches has really swung over because of that. And so what was illegal 20 years ago is probably very legal now. You still need to make sure, though, you follow the 2 tests of TLO. Okay? Now, let's talk about SROs at schools. With all the shootings that are happening and the school issues that are happening, every high school has an SRO. Most middle schools now have them. And there's even some elementary schools that are getting them. So I want to talk about the use of an SRO at school. Um, you, as a school official, only need reasonable suspicion. A law enforcement officer needs probable cause. So probable cause says known facts and circumstances are sufficient to warrant that that person would have it, which means essentially you have to be over 50% certain. So probable cause means in all probability that person has it, but that's over 50%. So you need to be at least 50% positive that person has it. Reasonable suspicion, you only might be 20% certain that person has it, but that's reasonable. The more dangerous the item, the less that threshold needs to be. So again, police have to have probable cause. You only need reasonable suspicion. Okay? Best solution, therefore, is always let school officials do the searching. Right? Always. Now, a police officer, school SRO can be standing there with you, but always have a school official search. And if you're searching a member of the opposite sex, have someone of the opposite sex in the room. Okay? Always do it in private. Never search somebody in front of other students. Now, if you have an SRO standing there watching you, that's not illegal. If while you're searching you pull out a bag of pot, you've now given that police officer probable cause to continue the search. If you find something on that kid, the police officer can use it to press charges. All right? And the other thing about this is if the child voluntarily consents to the search, then the police officer does not have to have probable cause. Now, the Supreme Court mentioned in TLO that you had to be aware of the student's age, educational level, mental capacity, all of that. The younger the child, the more you have to have the parents involved. So if I have an elementary kid, I would not search it until I contacted the parent. Even middle school, depending on what it is, I would notify the parent. All right? Or at least notify the parent as soon as I've searched, depending on what the item is. High school, that's different. I would always contact the parent that you had searched the child. Many kids don't go home and say, "Oh, Mom and Dad, the principal searched me today." But I'd rather have them hear it from me than hear it from the student. So you really need to be careful based on the age, the educational level, and mental capacity. So for example, the special ed kid that stole the thousands of dollars, we contacted that parent. Parent said, "I wonder where the money went." And we said, "We think we know. The child's handing out hundreds." So the parent actually gave us permission to search the child. That child's mental capacity, I don't think they knew what they were doing. Okay? Some school policies require students to provide consent. There are a couple cases that says that you need this. You really don't need this. And especially reason why is many of the school board policies have in there that you can search lockers and book bags and cars on campus. So it tells the students up front that they don't have lock solid constitutional right against search and seizure. So you really don't need to have prior consent to search. I want to go through about 10 or 11 of the best practices. So here's how I would do it. I did this in middle school, high school. We didn't have an SRO in elementary school. I would have school officials and I would train them on how to do the searches. And I'd do every search the same way. That way they can come back and say you're being arbitrary. So I would train my assistant principals. I would train, if I had an ISS teacher, I might have an intern. I trained them. So whoever I would allow to have searches, I would train them and we'd all do it the same way. Right? I would never let my guidance counselors search because they don't need to be, their relationship with kids need to be a guidance. And I didn't mean guidance counselors. I would never have my counselors search because they need to have a relationship different from them. One is going to try to find them and search them. But I might have a counselor present in the room watching me search. Okay? So, if you have an SRO and what you're trying to find is illegal or may be illegal, then they can be in the room to witness. Search in private, usually in an office. I would always ask the student ahead of time. First of all, if we escorted the child from a classroom to my office, I'd have someone walking behind the kid and I'd be in front or next to the kid to make sure the kid didn't drop the item or try and throw it in the trash can. Okay? When you get in the room, I'd ask the student if they had anything on them they weren't supposed to have, chance to give it up. That doesn't mean they're going to be forgiven. It just makes it easier. Be careful with that, though, because some kids will give up cigarettes knowing they have pot in their pockets. Oh, yes, sir, I have cigarettes. I shouldn't have it. Don't say, okay, don't search. You still search. I would always tell my students, look, I'm just doing my job. I have reasonable suspicion that you have something on you're not supposed to have. I don't tell them what I'm looking for. Just you have something. And my job is to keep the school safe. There's nothing personal about this. You know, you're innocent until proven guilty. If I don't find anything, then you're innocent. Right? And as far as I'm concerned, it's over. So, tell them that. Then I ask them if I can search them. Now, I don't have to ask, but it solves so many problems. If I say, so is it okay if I search your book bag and your pockets? They say yes, then they can't ever come back and say it's an illegal search. So I'd always ask. And if they say no, you can't search me, I say, well, guess what? I can. The courts give me the, law says I can search you, and board policy says I can search you, so I'm going to search you. Okay? If I'm looking for something illegal like pot or weapons, I might even ask, can the police officer search you? And if they say sure, then the police officer can go to it. I often do that with cars. Police officers are much better at searching cars than I am. So sometimes in a parking lot, I'm looking and I say, do you mind if he helps me? And they're like, no, go ahead. Bingo, go for it. He no longer needs probable cause. Then, put everything in public view. So everything out of the pockets, everything out of book bags, you put on a table or a desk so that everyone can see it, so they don't come back and say, you planted that on me. All right? Make sure that you're up to date on what you need to search. So for example, there are a lot of now things you can buy where a pen, you can open the pen up and inside the pen is a drug pipe. There's lipstick that you can take the top off, and there's a knife. So you need to be really up to date on these kind of things. If it doesn't look right, open the pen tops. Sniff the perfume. If they have a drink of water in their purse, uncap the water and smell it. Have them take their shoes off. Look inside their shoes. And when I was at Southern Wayne High School, they actually had flip-flops that in the heel of the flip-flop, there was a little compartment that it was hard to see, but you could open the compartment up and it would hold 4 ounces of liquor. All right? Put it in public view. Now, if you're searching a female, have a female staff member in the room. All right? Then, write down your account. So write down what you did to search, especially if you find something. If you find something, you need to write this down. Okay? In that write-up, let's say, for example, you find marijuana, you find a knife, put it on the copy machine and take a picture of it. And the reason for that is, if it's a knife or it's marijuana, it becomes evidence if you're pressing charges. And that's going to be taken to the courthouse and locked up. Well, you may need that for recommending long-term suspension. So if I found a knife and it's got a 9-inch blade, I'm going to put it out on the copy machine, put a quarter next to it so you can tell the size of this knife, so I can put it with the packet for long-term recommendation. Okay? Take notes, because if they decide to fight it, it may be, you saw we're in the TLO, it was a year just in Supreme Court. By the time TLO went through the court case, it was like 2 or 3 years had gone by. Well, it's hard to remember that. So if your notes, you can go back and look and say, yeah, here I searched. That's why it's so important to do all your searches the same way. If you follow the same routine, then it's easy to remember. Right? Contact parents that the searches occurred. And again, if very young, I'd say under the age of 14, I'd contact them before the search. If they want to be there for the search, they can. I had parents come out and say, I'll search them. I said, no. Here's board policy, says I can search. You can watch me search, but I'm not going to let you search. Okay? That's why it's so important to have your handbook and your policy saying you can search book bags, lockers, cars, etc. Again, there's a whole thing in here about that. I'm not going to go through this in too much details, but you need to have it. The other thing is this, is I would not let other staff members search. I don't let teachers search. I'd rather have them bring it to the school personnel to make sure we do it. You as an administrator have had school law and you know the right way to do it. The classroom teacher may not. Okay? Now, here's the other thing I recommend. After the search, meet with the individuals involved and debrief, especially if you find something serious. All right? So take notes, record, debrief, and learn from it. What could you do differently? Put in there who was there for the search. So I would put down, so-and-so witnessed the search. Put down the background of the person who searched. We have a student that has a reputation of hanging out with druggies. I had a call from an anonymous source saying that they were selling marijuana. So put that in there. If you ask permission and the child said yes, put that in your notes. Ask the child if they said I could search them. They said yes, that me and the police officer could both search. Because if that ever gets to a lawyer is going to have to say we can't do anything with this. All right? So write all that up. You're going to need it. If it becomes serious and goes to long-term recommendation, you need that information anyway to put in that packet. And so that's why I do it. And I debrief because I want to make sure that if we messed something up or we didn't do it well, that we got better. All right, now, let's talk about random searches. Often you'll have a cell phone stolen in the room. You know it was there. No one's left the room and there was a cell phone on the table and now the cell phone's gone and you want to search everybody. Right? You can do that. Okay? And you can do it as a preventive measure. We had metal detectors for everybody coming into the basketball game. We'd have metal detectors coming into certain football games. If you're going to use metal detectors, by the way, don't have them just for one or two schools that have been labeled bad. Use them for either everyone in conference or use them randomly with different teams. Don't just say our biggest rival, one of them was Goldsboro High School. We used to have a lot of safety issues. So I couldn't just use the metal detectors for Goldsboro High School and no one else. The problem I'd run into there is Goldsboro High School is minority, high population minority, and it looked like I'm targeting. And I wasn't. So we'd use our metal detectors multiple schools or randomly. Okay? But you can't do that because it is preventive. And again, because of what's happening in the schools today with the shootings and the stabbings, courts are more open to you doing this. Okay? Now, that really does not apply, though, when you're talking about drug-sniffing dogs. Drug-sniffing dogs cannot sniff the person. So, a couple times a year, you might have the drug dogs call you and say, we want to come search the building. They'd come to Southern Wayne twice a year to search the parking lot. It gives a chance for the dogs to practice. It also scared the crap out of our students. If you're going to do that, if they come in the building, they can search, they can sniff lockers. You can even take all the kids out of the room and let the dog go in the room and sniff book bags, but they cannot sniff the air around a person. And the reason why is because you have to have reasonable suspicion. People have an expectation of privacy of the air 3 inches around my body. That's my personal space, okay? But do not allow dogs to sniff around students. If they say it's okay, the police say it's okay, just don't do it. Another one is drug testing as random research. Now, that's really a county-wide thing. I don't know of any particular school that does this. Either the whole county approves it or they don't. A lot of times it has to do with athletics. And it has to do with if you have a history or if there is a problem with drugs a documented drug epidemic, then you can do it. Again, the reason why you get by with this in athletics is athletics is optional. It's not a right, it's a privilege. It's optional. So they have a lessened expectation of privacy. But again, you have to have a history of it that you're trying to stop before you can implement it. Okay? And it needs to be minimally intrusive. So a P test is less intrusive than a blood test. All right? If you required every athlete to have a blood drawn, you probably wouldn't get that passed. If you had them all pee in a cup, you'd probably get that one passed. Again, if you had a history of it. And there's some cases here that's listed that you can look at. So here's one that says drug testing for anybody who was fighting. Well, there's no connection between fighting and drugs. So again, it has to be the scope of the search at its inception has to be reasonable suspicion. Okay? So to keep schools safe, err on the side of searching rather than not searching. You are protected by governmental immunity as long as your search is knowingly or willingly not illegal. So no one's going to be able to sue you for searching if you follow the law. All right? That's why it's so important. So in fact, if you look at Harlow Fitzgerald, 1982, an administrator will not incur civil liability unless his or her conduct violates established statutory constitutional rights. So as long as you follow that, you're fine. They may be mad at you, but they're not going to be able to do anything about it. All right? This protects you of good faith in the gray area of the law. And searching is a gray area because reasonable suspicion is not defined clearly. All right? Anyway, that's all it is on searching. I will post these notes for you in this module so you can read them. And I will be posting videos probably every couple days, at least once or twice a week. Trying to do it on Wednesdays and Thursdays. This one is really just looking at notes and me talking. As I get to learn the technology more, I'll add more interactive things to it. But again, searching is important. Here's the other thing about searching, and I've had some principal friends of mine who, when they found things, did not want it to get out because they didn't want the bad press. The thing about that is, if you press charges, the pressing of charge becomes public record. And newspapers and TV stations, they contact local police stations on a regular basis to see if what charges are being pressed. So if you press charges for drugs, that's public record. Now, if the child's under 16, they're not going to print the child's name, but they're going to print drugs found at Southern Wayne High School. Or a knife was found at Southern Wayne High School. If you try and avoid this, thinking that your school won't get labeled, I have a problem with that. Two reasons. One is you may be breaking the law. I know of a principal who's no longer a principal who actually found 2 guns on campus and reported it to nobody. He didn't want it to get out that his school wasn't safe. And what happened is the mother of one of the students later told people that the gun was on campus, and when they investigated, they found out that that was true. That principal actually broke state law. He did not notify the police. He did not notify central office. He's no longer a principal. The second thing it does is, if that's on my campus, it's on every campus. So if someone says they don't have drugs or weapons on their campus, they're lying to you. Everybody has it. And I'd rather my kids know I'm searching for it and I'm going to find it, so they may keep it off more than they have it on. So I don't mind that. I'd rather have it be the front page than have me cover up and more kids bring it. If you ever have a problem with searching and you're not sure, you can always call the superintendent or assistant superintendent, someone up there who handles discipline, and let them talk to you about it. But I think you follow the guidelines that I've set forth in this little lecture, that you will do fine when it comes to search and seizures. So, thank you so much.